We're going to get started and call the meeting to order. We have roll call. Eugene Toast is here, Rebecca Hansen is here, Chris Buckley, Bill Bolton, I'm Steve Rhodes, and Sharon Penny, our town planner. Any public comments not related to the agenda this evening? Seeing none, we're going to move on to the agenda, and I'm going to go from the bottom on this and see, hopefully get the briefer presentations out of the way first. Is anyone here for the Veterans Housing at Boulder Point project? You want to give us an update?
Sure. Well, anyway, this housing project that you all have been familiar with. Soldier On was our development organization out of Western Mass. They run a great program, a lot of dignity, respect shown in the vets, a lot of autonomy. They just couldn't get the traction that they needed to get in New Hampshire that they were able to get in other states from banks and whatever. So Alex Ray and I have been working on this for about 6 years, and I've had some older vets at the shelter. I thought, oh my God, they're going to be dead by the time this place opens. So running a shelter, I've had a lot of opportunity to work with Harbor Homes in Nashua. And I have to say Harbor Homes really has the gold standard for this state and probably other states as well. They have all the veteran GPD funding. I work with their veteran outreach people, and they're unsurpassable. So they were willing to go to bat with us when we said to Soldier On, thank you so much, but we just can't make it work with the organization. There were these vouchers from the VA that were a critical component. So what started out as a 50-unit site will now be 30, and Harbor Homes was able to capture 25 of those 50 vouchers. That's the critical component, and they're going to add an additional 5 units so that there are vets who may not. I have a vet right now at the Bridge House. He's in a wheelchair. He gets a couple $1,000s a month, so he doesn't make the poverty level that would be necessary, but he could certainly have one of those other 5 rooms that he would be a candidate for. So Harbor Homes, it's in their hand right now. They are our development people. We're really honored to be working with them, and hopefully they'll have a shovel in the ground by the middle of May, which will meet the HUD criteria for moving forward on this project. Do you have any questions?
Sounds great. Sounds like you're making it happen.
Wish us luck.
Yeah.
And I have to thank everybody in this town and on these zoning and planning for being so supportive of this project. You guys have been terrific. Thank you.
Great. Thank you very much.
Kathy, just FYI, your actual site plan review for the previous iteration of this expires July 25th, so we'll have to see you.
Oh yeah,
before.
Harbor Homes has all of your
Cool.
dates down.
Excellent.
And they're getting ready.
Good.
Thank
Great.
you.
Okay, is Kevin French here? Seeing Kevin, so we're going to move on to the continuation to a date certain from March 16th, one-lot subdivision on PID 207-001 Fairgrounds Road. And we left things in March. The parties were going to go off and talk together and then come back and tell us what transpired. So I guess we're going to hear from folks and see what's up.
The surveyor's here, so maybe he could start us off with where we're at.
Yeah,
Hey,
just
Tom.
to give you a update from the March meeting.
Just, excuse me, Tom, just for the record, we didn't meet March, do we?
It says February 16th.
I'm sorry.
We started February, we were going to March didn't.
Right.
Just
Sorry?
for the public record. No,
Okay.
that's okay.
From the February
We'll all be
meeting,
confused.
as time flies.
Yes.
The board had some suggestions for changing boundary lines and access road, and asked the parties to go back and see what we could do about coming forward with an alternative. If you recall, there's 3 ownership parties in this property. The 3 parties have not been able to come to an agreement on any changes, so they would like the board to go forward and consider the application as it was presented.
Okay.
If I may, I represent one of the two co-applicants. I'd like to speak to how that transpired and how we got to the place that we're at with respect to that. If I could be heard on that?
Sure, absolutely.
Thanks. Can you just, for my kind of reference purposes, put a copy of the plan? I have some documents that I'd like, if I may, share with the board.
Yeah. Could you give us your name, please, again?
I'm sorry. For the record, my name is Bill Priebus, P-R-I-B-I-S. I'm an attorney from Concord, New Hampshire, and I represent two of the co-owners of this property, Florence LeDuc and Dennis Gerard. They're with me here in the room today. They're sitting apart because Dennis couldn't squeeze by me. I don't think they're at odds with each other or upset with each other. If anyone, we have sufficient copies to go around. If anyone from the public would like that, I'll set them on the chair. So just to recap, the last time we were here, the board was considering this minor subdivision application, and you gave us some suggestions with respect to moving one of the boundary lines, and one of the concerns was how wetlands may or may not be affected in this area down here. And my clients ultimately decided that they didn't want to agree to a change in that boundary line, and they came to that conclusion after considerable deliberation and with all due respect for the work that you have done and the suggestions that you have made. But in order to kind of understand why they made that decision, this is a very, very strange situation in terms of what should be a straightforward and simple subdivision application. And so I think it's important for the board to understand with some detail the backstory here, because we don't think it was fairly represented to you at the prior hearing. The parties involved are common owners of this area that we're proposing to be subdivided. And Attorney McCormick referenced at the last hearing that it was in fact subject to what's called a petition to partition. So this is a probate court proceeding where there's co-owners of property who want to be divested of that ownership, but they can't agree on how that happens. They can go to court, they can go through a process, and a judge can decide how the land's going to get subdivided or if it's going to get sold and the proceeds are going to be divvied up, something that's fair to all involved. The parties present evidence and the judge ultimately makes that decision. As part of that process, oftentimes, and in this case I believe everybody agreed, the parties went to a mediation. They sat down with someone, a facilitator, someone that was going to help them try to reach some sort of an agreement so they didn't have to give evidence to a judge at a trial and have him decide how this land was going to be divided up. So they sat down with a mediator, and it was a day-long mediation, and it took place in the Plymouth District Court across the street, or what I guess is now the Plymouth Circuit Court. And I'm going to read what Attorney McCormick said about that mediation at the last hearing. And I'm quoting. He said, "There's an action called Partition in New Hampshire whereby people can have the court divide the property for them." So we got to that, and at a settlement conference one day across the street, a lengthy conference, trying to resolve it amicably, there was a sketch put down on a piece of paper. The lights were going out literally. That sketch has morphed into that, and that being the application that's before you. What happened was, after the settlement conference, the Batchelors and Kelseys actually overlaid the sketch onto a real plan. To their shock, they realized that the access was very close to David Cote and were going through wetlands, and that wasn't the idea. It goes on to say, you should treat this application as any application. This one is different because basically, normally you'd have a land planner or surveyor who would sit down, analyze the property, they'd figure out the best place for access, minimize wetlands impact and all that. I dare say, Tom, and that's Tom Hand, the author of this plan, I dare say Tom would probably say that's not the way I would have done it. But we're just a bunch of lawyers and bozos. What do we know? We had a pencil and a piece of paper, and it seemed right at the time. So the impression that was attempted to be created here was that a couple of yahoos, some bozos and their lawyers, sat down in a dark room and tried to sketch something on a piece of paper that our land planner never would have done. And that's, unfortunately, that's simply not the case. In the package of documents that I've given you, tab number 1 is a document entitled Mediation Report. And this is what resulted after the parties sat down for this day-long mediation across the street. In the first page, it's in caption, Mediation Report. It's dated 11/23/2009, so some 7-8 years ago. And this is Michael Lonergan, the mediator's report as to what happened at the mediation. And the next document is the actual settlement stipulation that the parties signed. And if you thumb through that and go to the very end, we have the infamous sketch that is the basis for what you see here before you today. And I've highlighted on the second page of tab 1, and by the way, all the highlights in here are my highlights. They weren't in any of these original documents. But hopefully for brevity's sake, I highlighted what I thought was important. And basically, the parties agreed at this mediation, within 14 days, respondents shall supply a sketch depiction of a parcel containing 50 acres, substantially as depicted on Exhibit A, which is the last page of tab 1. The lot line shall be approximately along the line X, Y, and Z. And then on the next page, paragraph 5, I think this is significant too. It says the respondents, and the respondents are our co-owners, the Kelseys and the Batchelors. The respondents' access over K3 shall be in the form of a, quote, Woods Road, end quote. And then there's a couple of signature pages that I can talk about, but then you have at the end of tab 1, the so-called Exhibit A. Now, this is the document that counsel would have had you believe after this first hearing that a bunch of bozos and their lawyers in the dark tried to put together on some piece of paper. What, in fact, you're looking at here is a document that was prepared by Tom Hann, a licensed land surveyor, and brought to the mediation. The only thing that was added to this document is the line that I've highlighted in yellow here, the line depicting what is to be the boundary between these two parcels. You see at the bottom of that line there's an X, and it goes up to a Y, and there's a dashed line that's highlighted there. That's the only thing that was added to this during the mediation. All of the other lines, including these ones demarked K1, K2, and K3, and then you can see over to the right of that a G1 and a G2. These were placed on this document by a licensed land surveyor. And the reason he placed them there was because prior to the mediation, he was assigned the task to come up with what might be appropriate access points, what might be appropriate accesses for this property. So I really feel the need to disabuse anybody of the notion. What we've been focused on is not necessarily the location of the boundary line, but concerns over the access, driveway 3, where it's located on the proposed application. Well, the genesis of driveway 3 is what the parties agreed to at the mediation, that the access, which is marked K3 on this Exhibit 3, would be the access that the Kelseys and the Batchelors would use, and it would be in the form of a Woods Road. And this K3 was not drawn in the dark by some bozos and their lawyers. This K3 was put on this plan as a potential access point by a licensed land surveyor well prior to the mediation, and that's the basis for this. So I think it's important for you to know that. I don't want the board to have the impression that the thing that we're concerned about with this driveway 3 has its origin by some folks and their lawyers trying to scratch something on a piece of paper in the dark. This is the work, the genesis of this plan, and particularly the location of driveway 3 is the work of a licensed land surveyor, Tom Hann, who's here tonight. So this is the agreement that everybody came to, and we thought it was very straightforward and would be fairly simple, and it turned out obviously not to be the case. At tab 2, I've annexed the Judge Gerald Boyle's Gary Boyle, I'm sorry, he's approving this. He is improving the parties' settlement stipulation. And he's not just approving it, and I think this is significant. He says approved and so ordered. This is not just an agreement that parties have reached. It's something that the probate court has approved and has made an order of that court. So it's no longer just a settlement agreement. It's an order of a court of the state of New Hampshire. Some time passed, and we believed that our co-owners, the Batchelors, and the Kelseys were not doing what they were supposed to do per the settlement agreement. So sometime later, we had to go back to court before Judge Boyle, and we had to ask Judge Boyle, please, enforce the settlement agreement that everybody agreed to and signed off on. And that ultimately happened. But it only happened after Judge Boyle had a trial, during which he heard evidence, he heard witness testimony. I believe it was a day long. He read exhibits, he heard from some of the parties, he heard from Tom Hand, and he issued the decision that I've annexed at tab 3. And that's an April 10, 2012 decision, so now some time has passed. And I've highlighted a few provisions of that. Judge Boyle says, testimony was presented, and this is on the second page of tab 3. Testimony was presented by Dennis Gerard, Thomas Hand, Frederick Kelsey, and William Batchelder. Numerous exhibits were introduced. He says the court has considered the evidence submitted at the hearing in the form of testimony and exhibits, and the court has deliberated. The court also listened to portions of the recorded hearing. So Judge Boyle, after hearing a day of testimony, after reviewing these exhibits, after deliberating for a considerable period of time, and after going back and actually listening to the record of the hearing, ultimately on the next page says, the court enforces the settlement stipulation previously approved and so ordered. And turning back to the first page of the order, he said that the evidence is that the mediator drew the XYZ line in the presence of those who attended mediation, and K3, K2, and K1 were on the sketch plan prior to mediation. So that's what I've just described to you, that these access points, the K1, K2, K3, had been done by a licensed land surveyor, Tom Hand, prior to the mediation. Evidence is that Exhibit B depicting K3, K2, and K1 and the wetlands was prepared for respondents and was the precursor to, Exhibit A. So again, Exhibit A to the settlement agreement, which ultimately became the plan that's before you in this application, was prepared for the Kelseys and the Batchelders by Tom Hand prior to the mediation. It wasn't done in the dark by some bozos and their lawyers. Thomas Hand testified he believes he shared Exhibit B with respondents prior to mediation. Exhibit B, and I'm sorry, which became Exhibit A, which became this, again, this is what Judge Boyle found the evidence to be. So I fully understand that this decision is in absolutely no way binding upon this court. But the issue of wetlands and how this would affect wetlands was discussed, I said court, I'm sorry, board. The issue of wetlands was discussed at length before Judge Boyle, and as a reason why he should not approve this settlement agreement. And he heard that evidence, he deliberated upon it, he looked at exhibits, he heard the witness testimony, and he said, no, this is an agreement that should be approved and should be enforced. And so I'm not saying that because Judge Boyle said that, this board has to follow his lead. You absolutely don't. However, I think you can take some comfort in the fact that if this was something that was going to be devastating to the environment or the like, which it absolutely is not, then a judge of the probate court has looked at these issues and he has determined that, no, this is a settlement agreement that should be enforced. We continue to believe that the Batchelders and the Kelseys did not act in compliance with the settlement agreement, and we went back to court again, this time in 2016. And I've annexed to tab 4 the October 27, 2016 order from now Judge Rappa of the Grafton County Probate Court, in which he basically says, you need to submit this application that accurately reflects Exhibit A to your settlement stipulation to the planning board, and I think he said by December 21st, 2016. And that order is dated October 27, 2016. So now a second judge has looked at this and said, you know, this is a valid agreement, it should be enforced, and you need to submit it to the planning board. And again, I don't say that because I think that you are required to follow what these judges have said. I just say it to note that other folks have had a look at this and they have not seen issues or problems with it. So that's the process by which we got here today, and it's a rather tortured process, and it's kind of an odd process because folks have different positions on this application amongst the co-owners of the land. But so the reason that my clients did not want to agree to give up acreage as proposed by the board has a lot to do with this kind of lengthy process that they've been through. The mediation that we went to was a day-long affair, and there was, as there is in these situations, lots of give and take during that mediation. And we made some concessions that we didn't feel we wanted or needed to make, and I'm sure the Batchelors felt the same way, and I'm sure the Kelseys felt the same way. But at the end of the day, we walked away with the amount of acreage that we were comfortable with, and it was significantly less than what 1/3 of this would have been. So there's basically 3 co-owners, and if you're dividing this up 3 ways, the amount of acreage we walked away with was significantly less than 1/3. It was about 50 acres. And so the proposal that the board had made, and I've attached at tab 6. Tom took the area of the plan that we're concerned about here, and I think he described it as decluttering it a little bit. But this is from that plan, and what he's indicated here is you can see the original line, that's the red line with the 2 dots in it. That's what was proposed in the original application. And to the right of that, you can see the yellow line. That's what the board proposed that we move that boundary to. And so that swath of land between these 2 lines is what my clients would be required to give up in this process to the Kelseys and the Batchelder, because that would become their land. And that's not what they agreed to, and it's a significant parcel. I'm eyeballing it, but I'd say it's at least 6, maybe 8 acres. And so what they would be asked to do is something that they wouldn't have agreed to in the first instance, and they're really not comfortable agreeing to it now. A, because they wouldn't have agreed to it in the first instance, but B, it was such a long, expensive, stressful, and difficult road to get to the point where we're at now. And they just don't want to backtrack in terms of giving up the less than 1/3 acreage that they ultimately received. But there's another really good reason that I'll get to in 1 second, and that I think the board should be very interested in. But that's why my clients did not agree to shift this boundary line. They're not being greedy, they're not being obstinate, they're not trying to pick a fight with anybody, they're certainly not being disrespectful of this board's suggestions, but it's been a long, hard road to get here, and they simply don't want to backtrack. So what we would urge the board to do is to consider the merits of this application as submitted, and to ultimately approve it as submitted. And I just have a couple of brief points I'd like to make with respect to that. The focus and the concern at our last meeting was on this driveway 3 over here, and how it might affect wetlands in this area. And as we're sitting here today, it's not going to have any effect on wetlands, because we're not proposing with this subdivision application any development whatsoever. We're just basically asking that the boundary lines be changed. Yes, there's a driveway indicated on there, but nobody's telling you that they're going to build that driveway. Nobody's saying we're going to pave it, we're going to do anything that would affect wetlands there. We're simply indicating that it's there and it may possibly be used in the future. And of course, this board can and should consider the future potential use of that property. But I would ask that you do it in the context of what its historical use has been. And its historical use, as long as my clients have owned the property, which has been a considerable period of time, and I'm quite certain as long as anyone in this room can remember, the historical use of what's being subdivided off here, and indeed this entire lot, has been sustainable timber harvesting. That's it. There's been no development. There's been nothing other than sustainable timber harvesting that would take place once every 10 years, and it would take place during the winter months. So that historical use has no effect upon wetlands whatsoever. The ground is frozen. They go in once every 10 years. They timber and take timber out in a manner that's manageable and responsible, and that's it. The likelihood of that continuing in the future for a long time is very, very high. as I'm sure you have surmised by now, the folks, who would be getting this parcel are very conservation-minded, and I think in all likelihood, there's very little danger that any future development is going to happen up here that would affect wetlands. But, assuming that that's not the case, if you look at tab 5 in the packet that I provided, this is an earlier subdivision that's referenced in our in the plan that we've actually submitted. I think it's the so-called French map. And what we've been focusing on is this area down here. But if you look at this document, and roughly this big northern chunk up here to the top of the paper is what the Batchelors and the Kelseys would receive as a result of this subdivision and settlement stipulation. And that land, there's we're talking about some wetlands down here. I mean, we have the granddaddy of all wetlands right in the middle of this thing. That's completely surrounded by steep ledge. I think the likelihood of some developer coming in and saying, I want to put in a 30-unit subdivision of single-family homes or some commercial project or something like that is slim and none. It's land that simply does not lend itself to that type of thing. So this concern about future development, I think, is really a pretty significant red herring. In fact, we've even indicated on this map, and I think it's note 7, that really the practical use is to build a single-family home right down by Fairgrounds Road. And if somebody did that, they would have a heck of a backyard. But it's not going to affect wetlands. It's not going to result in any sort of paving of the driveway or anything like that. And as far as that's concerned, this driveway 3 that's depicted on there, I think you can take some comfort in the fact that there is a document that's a matter of public record in the probate court that says that the parties to this settlement stipulation, which is a court order, agree that this driveway 3, K3 on the settlement stipulation, will be accessed in the form of a, quote, Woods Road, end quote. Now, Attorney McCormick said the last time that that doesn't have any legal significance. Well, it's in a court document. It's a court order. Maybe the term Woods Road is not a legal term of art, as they say, but it means something, and just because we're talking about legal things doesn't mean we abandon our common sense. And common sense tells us that we might not be able to define exactly what a Woods Road is, but we certainly can define what it's not. And it's not a highway that's paved. It's not a driveway that's paved. It's not a driveway with curves and drainage and stuff like that. So if somebody came in here and said, I want to put a paved road over driveway 3, I think you'd have a pretty good argument that no, you can't do that. There's a document out there that says the use is going to be limited to a Woods Road. And in any event, whatever happens to the area depicted as driveway 3 that has no plans for development right now, the wetlands are going to be protected in that there's going to need to be some agency involvement looking out for those wetlands. And that's as simple as even if somebody wanted to log it in the summer, if they were going to affect wetlands, they'd have to go to DES and they'd have to get the necessary approvals and they'd have to show how they're going to protect wetlands. I believe, given the wetlands that are out there, there's a good possibility that that would come to the town as well. And certainly if somebody planned to build back there, that's something that the town would be involved in, and you could adequately oversee that any wetlands there would be protected. So we think the likelihood of development that will affect wetlands is really slim and none. And what you're very, very likely to be dealing with for the long foreseeable future is a situation where this area is logged in the winter and wetlands are not harmed once every 10 years, and that's it. So for those reasons, we think concerns over wetlands, why they are something that this board should pay attention to. The evidence is overwhelming that it's not really a valid concern. And then there's one other interesting thing that we considered, and I'd like the board to think about, and that's this. If you look at tab 6. You can see the boundary line in the application that's been as submitted, and that's the red line with the 2 dots that goes up kind of the middle of this, and you can see to the right of that a yellow line, And that's the line that the board suggested that we move that boundary line to. That's the portion of land that my clients would be giving up that they agreed they would get in the settlement stipulation. And if you track that yellow line down, it runs into another lot that actually is owned by my clients as well. And then to the left of that yellow line, which turns into the red line, is a driveway, and it's marked driveway number 2, existing. So driveway number 2, existing, as we speak and as this application was submitted, is the manner in which my clients would access the portion of the subdivided land that's going to them, the land that's to the right of the red line. If you shift that red line over to the yellow line, that driveway is no longer on land owned by my clients, but rather it's going to be on land owned by the Kelseys and the Batchelors. And so that manner of my clients accessing the property that they would be given in this application from Fairgrounds Road is gone. They have to come up with another way to access it. And it can't be anywhere to the left of this lot, of this yellow line, because all of that property is no longer theirs. So that's significant, because if you turn to tab 5, this is the prior subdivision, and what I've done on tab 5 is I've outlined in orange and drawn in the line that the board asked us to consider. And you can see that line comes off of Fairground Road. It travels next to the lot that's not at issue here, right along that border, and then it bangs a right, and I just added an arrow to indicate that it is going to continue in that direction. So my clients no longer have any access, as they had before, to the left of that orange line. So the only access that they would have is to the right of the lot that's not at issue here. And I've outlined that in yellow. So if the subdivision application was approved with the boundary moved as the board suggests, what would happen is they'd have to access in the area off of Fairgrounds Road that I've indicated in yellow. And lo and behold, directly above that is a much larger wetlands area than anything that we're talking about here. So a practical effect of moving that boundary, and one of the reasons that my clients didn't want to move it, is it has the potential to have a more significant effect on wetlands in terms of what they would need to do to access the property that they'd be given as a result of this subdivision. And they don't want that to happen. The impact, we believe, to wetlands, if they were to access to the right of that lot in the area shaded in yellow there, the effect on wetlands would be far more significant than what's proposed in the original application to the board. And finally, what was proposed in the original application to the board, and kind of the scientific or the expert evidence that we have here, is highlighted in tab 6. I believe at the board's request, Tom was asked to have the wetlands had been demarked by a wetland scientist, and it was asked that they be included in this. And this was a result of that process. A wetland scientist flagged the wetlands in this area, and the wetlands, and Tom depicted the boundaries of those wetlands as flagged by the wetlands scientists, and that's reflected here in Exhibit 6. In Exhibit 6, you can see driveway 3. Yes, it affects some wetlands, but it's not this massive, massive impact upon wetlands that's being suggested here.
So I have a question. Can I interrupt for a minute?
Of course, absolutely.
So this wetland survey was done since the last time we saw you guys?
No.
No, that was the prior meeting into the informational, if you will, in 2012. We had made a request, the board had made a request on February 16th for perhaps getting a wetlands report from the soil scientist who did the delineation that is shown on all the exhibits in the
Okay,
most
so this-
current
all right.
survey. And I haven't seen that to date, so I don't know where that's at.
Okay, thank you.
So according to this, the impact on wetlands, while there will be some impact, is not as significant as I think folks are trying to indicate. So for all of those reasons, I particularly want the board to understand that this was not just a willy-nilly thing, but that it was based upon professional advice of a land surveyor from the very beginning. For all of these reasons, we would ask that the board approve the application as it was originally submitted. I think we have a situation here where you have an opportunity to create a very significant likelihood that a significant portion of land is going to be treated in a respectful and, well, all of this land will continue to be treated in a respectful and appropriate fashion. And I think you will have the opportunity, if someone's going to do something to disturb wetlands over here, you'll have the opportunity to be able to control that and oversee it. And I think that's your burden to hand here. If the application is not approved, then we have our bird in the bush. And that bird in the bush is we go back to probate court and nobody knows what happens then. If we go back to probate court, the judge could say sell it, the judge could say auction it off, the judge could divide it up in some different way. We just don't know. And that could have effects, that could have a result that's far, far worse than what's being proposed here, to the extent what's being proposed is even bad at all. So I think I would urge you to select the bird in the bush, so to speak, and to approve this application as originally written and submitted. And to the extent you don't, we'll certainly respect that decision. And I know this is provided for in your rules, but I would respectfully request that you in fact issue a written decision as to what violation, what subdivision regulations or ordinances this violates, because in our view it's a good proposal and it should be approved. I know I've been long, so I thank everyone for their patience. I appreciate it very much.
Thank you. Board have any questions for this presenter?
I got a concern, or at least a question about the actual wetlands that's depicted on this or that, and the one that you indicated in Exhibit 5. You have this large wetland area right behind the Gerard and Leduc property that doesn't appear on that.
That's because I believe we were told to focus on wetlands in this area. And actually, if you look, and you can see it on Exhibit 6, too, which Exhibit 6 is a blow of what's out here with some of these topographic lines removed.
Right.
And you can see it's kind of right there. That's just the start of the wetlands that's depicted above this lot in this area right here. So it's a rather significant wetland all across.
As well as the larger wetland area, you know, even further into the property. It doesn't appear on this, but you got the mother of wetlands back in there that you indicated.
No, and again, this doesn't even, and I think maybe that's a little bit of the problem here, but this map doesn't depict the entirety of the property. There's more property up here that is going to go to the Batchelors and the Kelseys, a significant amount of property. But I believe we were asked to depict it in this fashion, and Tom can correct me if I misspeak. But you know, because it was so large, and because the focus was on that, this is the part that's going to be affected, and this is the part that's going to be affected in that issue. All this up here, which would go to the Kelseys and the Batchelder, would remain as it is. And that's, so if you're looking at tab 5, the
Excuse me one second.
No, that's okay.
It comes to another map, that's how huge it is.
Right.
So that's, even the tax map only shows a portion of this existing large lot.
Okay.
it's a big piece of property. And so, you know, what I refer to as the mother of all wetlands would be, you know, approximately right up here, and a lot of ledge and stuff like that. And this is the area
It
that
looks, you know, just to, I mean, it doesn't look like it's way up there. It looks like it's, at least as depicted on this thing. But you got it located, you know, like,
yeah.
okay, it's not quite that far up, but,
I'm no cartographer, so forgive me if I'm
And there's also the existence of driveway 1, which, I mean, even if, I mean, I guess if you can't agree upon moving the lot line, but there's driveway 1 that the Ledukes and Gerard can access the back 40.
Right. And again, the concern there is that there's this wetlands area right up here.
Where's driveway 1?
It's this one right here.
Oh, over on the other side, okay.
Here's the,
Yeah,
that helps.
yeah, I see it right here. There's no way that, without adjusting any property boundary, driveway 2 could be used by all parties if they only have to get up there once every 10
That's
years?
the problem. All the driveways.
Well, if it's just a logging road, or is it that people have to get access every 10 years? It can't be a right-of-way for everybody to use?
My clients did not want to agree to that because of the proximity to the property that we own. I touched upon that at the last meeting.
And that green line on map on tab 6,
Yeah.
that was a proposed extension that would connect to that driveway above the house, above the lot.
Yeah, but proposed by the planning board.
Yes, yeah, because I'm trying to remember what we had, because I totally get not wanting to give up all that property.
Right.
I mean, I absolutely understand that. And I also understand not wanting other people's logging trucks driving right by your property, which I think is probably one of the reasons that Dr. Cody objects to driveway number 3 going right up his property line, if I'm reading that correctly. So I just wonder if a compromise wouldn't be that green line, which would avoid logging trucks or whatever's gonna go up there going by the Leduc property, but at the same time avoiding building a whole new road that's gonna go through some wetlands.
I think one of my clients' concerns would be the effect that might limit their use of the portion that's being subdivided and deeded to them. To kind of further touch upon that, there is a potential for a house lot to be placed up here. And it's something that my clients might be interested in pursuing at some point in time. And that being the case, granting a right-of-way for logging might affect that potential use or the value of that use. And so that's one of the reasons that they're concerned about that. The other is, this is a house here. So this logging road is not just, close to raw land or current use land. It's right next to their house.
And that's why I think we came up with the green
Right.
line, but.
Any questions from the board at this point? I think I would just like to point out that I think our suggestion on moving the property line was not to decrease the acreage.
Oh, I understand completely.
But to
And
keep the acreage the same for both parties.
we didn't,
There was a misunderstanding there, I think, on your part.
okay, when it got diagrammed out for us, it looked.
Right, one of the other points needed to be moved to balance the acreage, but that obviously didn't happen, and the parties are in no mood to make that happen, so I just wanted to point that out.
Okay. Thank you. And thank you all for your time. I know I spoke at length, and I appreciate you hearing me.
Any other comments from the board or anyone else that are presenting for the parties? Yes.
Guy speaking?
Yes, you may, of course.
Actually, I didn't think I'd be speaking tonight because last time I was here, I thought the board cut off all public input and was in deliberation session, so I didn't expect to have this much discussion tonight. And Bill was so quiet last time, I'm surprised that we heard so much this evening. We're not in the probate court. It's abundantly clear. Now, Attorney Priebus has read several pages from the very, very long novel that is our litigation. It was a 9-year, going on 10-year litigation, and it's been very difficult. And a long portion of that was spent in trying to move that right-of-way from away from the Cody boundary to someplace else. And unfortunately, that didn't happen. Now, I would stress a few points, clarify a few points. No judge has ever passed on the merits of that land plan. The issue before the court was whether or not the settlement should be enforced. In the very terse opinion, it was. But it's nothing to do with this board. You are not the Superior Court, not the probate court. You are the planning board. As I said last time, I tried to spare you all that history. I made glancing reference last time, and Bill didn't say anything. But the last time we were here, I thought the board should focus on the merits of the application. Much of what's been said is between the parties, our dirty laundry. It's not yours. I think that the board should just do its job. You should analyze this like any other application. It's not important who said what, who was right, who was wrong, who did not cooperate. A 10-year case exists for a reason. I think that the board should do your job and simply focus on the merits. All that we've been discussing is somewhat irrelevant. A couple of comments. The Woods Road, last time we were here, we discussed the fact it's a wood road now, but the Woods Road may be something else in the future. At that time, Bill agreed. He agreed that the Woods Road did not create any future burden. Tonight, you're getting a different story. I suggest to you that the creation of a Woods Road is simply the here and now. Anything can happen back there. That Woods Road will be used for timbering, recreation, snowmobiles, skidoos, all that roads get used for. More importantly, a title search of this property would reveal that this existing right-of-way near the Gerard Ledoux property line, there's a right-of-way in favor of our seller, Norco. Norco conveyed the property to the parties. Norco retained a right-of-way to pass and repass over the right-of-way by the Gerard Ledoux boundary. So that right-of-way will exist whatever we do notwithstanding. So that right-of-way is here to stay unless Norco deeds it away. It's a matter of title history.
And what's the location of that again?
It's the existing roadway shown on the plan next to the Gerard parcel. That existing roadway.
Driveway 1?
I can't tell the number. Right here.
Oh, driveway 2.
That existing driveway we discussed last time is, to my understanding and belief, the subject of a Norco easement to pass and repass, for timbering most likely. So when the Gerards and Ledouxs bought the property, they should have realized that that right-of-way was for a timbering company, Norco. The settlement that Bill talked about was not meant to slice up the property evenly. It was based on value. Not that you should care, but the Gerard Ledoux parcel is far more valuable. In other words, the equity was not on the acreage, but rather on the relative values of the parcels. The future use cannot be predicted. We talked about this last time. There is a road going through the wetlands. That road may stay the same, it may be enlarged, it's as simple as that. But to suggest for a moment that that somehow confers a benefit on the environment is somewhat laughable in my opinion. And that's pretty much it. But the board is here not as a court, it's rather to focus on the four corners of the application and the plan. It's very simple. If you like the plan, you should approve it. Absolutely should. If you think it meets your criteria, it's a proper land plan, you have an obligation to approve it. And if you want to defer to the Conservation Commission, you can do that too. But you are not a Superior Court, a Supreme Court, you are the Planning Board. You should exercise your jurisdiction as a planning board. Thank you.
Thank you. Any questions for the board? Chris?
I think I'd be more comfortable seeing the property on the ground. I mean, it just seems prudent.
Yeah.
And particularly as I'm the liaison for the Conservation Commission, so I think due diligence would sort of dictate that.
Yeah.
Bill?
So you made reference to the Norgo right-of-way, and, can you describe that or give us a location of that? So, or where's that exist?
I don't have the deed. I didn't expect to be doing this tonight. Again, last time we were here, the public input was closed off, so I thought we were watching you deliberate. I don't have my entire file. Maybe Tom recalls. My memory is, it's over, I think it was depicted on the survey showing the Norco parcel as being in the same place as the current road next to the Gerard property.
On the original survey?
Right.
I brought a copy.
That's my memory.
Norco or Norgo? What's the?
Norco.
NORCO, I have the original survey here. Copy of it.
And he's not showing it here.
Isn't showing it.
So this is the, and that goes all the way up in.
Here, yeah, and it actually goes all the way through the property here somewhere. It's just
The one that starts on George property?
this one here.
Yeah.
Right, right, yeah. So there's an easement in favor of Norco over that same property. Yep.
Yeah, and he doesn't, on this particular plan, he did not show the beginning of it, he just shows this middle section.
Where is it?
It actually, on the ground, it comes through here and it goes off the property. I have not researched it. I'm not
Well,
sure
this
if it's
kind of like
more-
shows it more, ending like up farther, but
Yeah, this one.
Yeah, and we're, this plan doesn't show the whole property, but on the topo map, I just know for a fact that on the ground, it comes up through here and then goes off the property onto the other. I have not researched it, I don't know if it's an old town road, maybe before Chasen Road was even in existence.
Do you know if it's an easement?
I do not know at this point in time without doing some more research on it.
My clients were absolutely unaware of any easement of that nature.
We need,
Do you have the deed?
we
from
need to
Norco
have this
today? Do you have a copy of that deed?
I don't think I have it with me, but let me check.
Any more questions from the board at this point? We're going to open a public hearing here for a couple minutes. And then after that, we'll come back to the board for more questions. Anything else from the board right now? Okay, we're going to open a public hearing. It is 22 minutes after 7. And we'd like to hear from anybody that's in favor of the proposed.
I would take a butters first, Mr. Chairman.
Sure, the butters can speak first. That'd be fine.
Good evening. I'm Joe Driscoll. I'm an attorney from Laconia representing David Cody. He's the abutter that would be most immediately affected by that additional driveway that really has been the contention that's been before you folks. I spoke last time this plan was before everyone, citing our various reasons, largely related to the fact that these are wetlands. And again, as you can see from this, that's largely where they're delineated. So, presuming that everything we said before obviously is part of the record and for your deliberations as you go forward, I don't want to waste your time and repeat. But with all due respect to all the parties involved in here, that's litigation between them as co-owners of this parcel. Mr. Cody was never a part of that litigation, yet he's being affected by something that they're trying to enforce here. As you can see, I've quickly gone through these exhibits that have been brought forward. In tab 4, the last page, it says the court further orders the respondents shall file the subdivision application with the planning board, Plymouth Planning Board. The court absolutely recognizes that you have every authority to do everything you would on any normal application. This was, and you can see from the order, this, again, not a party to litigation, so I'm not familiar with the pleadings that were filed there. But having been through many issues like this was an effort to enforce a settlement. That was a judge trying to figure out whether there was any reason to set what everybody agreed to aside based on how they came to it. It's not a tacit agreement with what they came up with. He could have thought this was the worst agreement in the world. But all he was saying was that how you got there made it enforceable. So I want to push all that aside. I know the wetlands have been called a red herring, but I frankly think the court proceedings are a red herring here. The court understands that you have the final say. The court respects that completely. They have no control over your actions, and if the board disapproves this and everybody's got to go back to the drawing board, the court has to respect that. So that is not a question for you. That is nothing that you folks should really be putting ahead of any of the true concerns that you have as a board. Last time I was here, I went through the litany of references in the master plan, the zoning ordinance, the subdivision regulations, site plan approval, all having to do with Plymouth, this community having decided wetlands are imperative to be preserved here. And this driveway here that's being suggested along the boundary line cuts right through there. Now the board, we were very happy when we left the last meeting. Again, I thought I was just coming to watch a deliberation on it. We were happy that the board offered up some sound advice to these parties that apparently was not heeded. There was a boundary line adjustment that could have happened. Now apparently there's a question as to easements regarding that road. I do think the recommendation that the board gets out there would not be a bad choice. So you can really understand it, but honestly we think it's plain that what's on paper here, that what's being asked plainly cuts against the goals that this board is set to protect. It's going through the wetlands. If you went out there right now, hope you all bring your boots because you're going to be slogging through it. This is just not the appropriate means to do this. It's unfortunate they can't get together, and they haven't been for the better part of a decade, to figure out how to deal with this access. We don't care about this line or the property division. We just care about the driveway and what the implications that has. If we are talking about something that's only going to be crossed once every 10 years, the question's been raised, why can't an easement be exchanged, and boom, you're all set. So it's more of a question that the parties can't work together. And if that's the case, this is what's in front of you. And the future use becomes a very real thing. I understand that right now everybody's under the belief this may not be used. And that may be 100% correct. But this approval and any action on this approval carries with the land. So the next owner could do something. So we can't think of these things as, oh, well, I know the attitude of these folks, they're not going to do it, they're not going to abuse it, they're not going to take advantage of it. Somebody could. So you have to think with that foresight, and I believe this board absolutely does that, and you folks thought of every little permutation to get us to a solution that Mr. Cody's happy with, and he's my client, and that's the one I'm caring about in this situation. To avoid these wetlands, to preserve that area, any of the indigenous wildlife there, plant life, et cetera, to be protected. It's your duty as a board based on all those various documents you operate under. So I'd simply ask, if this is what they have to come to you with and can't compromise on it, that you don't approve it. Thank you.
Yes.
I'd like to correct one thing I said before. Judge Batchelder called my attention this morning to the fact that the Norco easement was reserved in that deed. And I recall seeing it. And in checking Tom's copy of the original deed, I don't see it in that deed. Now, it's possible, A, we're both mistaken, or B, a second deed exists, a corrective deed. But just for the record, nothing I see in Tom's file yet reaffirms the fact there's an easement over that road I talked about moments ago. Just so I'm going to correct the record.
Any other abutters that would like to speak about this project? Yes.
Don't have much to say. Everybody's hashed this out so many times that I'm sure you're tired of listening to it. Dave Cody, abutter. And the only thing I have to say is I don't know, I might be the only person here that remembers this land 45 years ago, but there was a very, very large, actually, you're very right, there's a very much larger piece of wetland right behind the existing house. It's not on here, but if you look at a wetlands map, that might be on some of that. That big piece, that yellow spot, right, exactly, right there. It's actually very big, and it's behind their house. And 45 years ago, that went all the way. That whole piece of wetland went contiguous and into my property, or to the piece, the big rectangular piece that we're talking about. It came right behind that house and went right out into this wetland and was part of it. This was all one wetland. So, and the only thing different between 45 years ago and now is the road that's there now. And that road that there's, to say that a road through here is not going to have any impact or have minor impact over the next however many years is totally ludicrous. And if you think that putting in a, believe it or not, as far as I'm there, and I used to drive a skidder for a little while, and putting in a woods road out here, putting in any road out here is going to have some detrimental effect, regardless of what it turns out and looks like and how much moss grows on it. It's going to have a huge effect on this piece of property right here. Just like it has already in the past 45 years, it has diminished and diminished and diminished. And the only thing standing between its being gone in the next 45 years is you folks. So do what you think is right. And if and God forbid, if this has to go back to probate, so be it. You know, that's not your problem and it's not mine. You just have to do what you think is right. Thank you.
Can I ask one question? So do you recall any logging operations that have gone on if you've owned that piece of property for?
Since I've owned it?
Yeah.
Minor, yeah.
So like every 10 years or whenever the 20 years or?
How long has it been? I mean, you guys know, you probably know, or Kevin French or somebody, whoever's been out there doing all the work.
Yeah, our company, oversaw has been overseeing forest management out there for a number of years now.
I mean, I know some guys that have logged, Gary Ladd logged out there further on Chason Road up on the hill there for twice, I think, in my
I
lifetime.
think over the last 15 to 20 years, there's been 2 logging operations.
Yeah, I think so. I know another one of my friends, Jamie Tillotson, logged out there.
So this wetland extends onto your property?
Did in the past, apparently.
It abuts it. I mean, my land is all in floodplain anyway, so.
And some of the wetland is been
The
cut in half?
wetlands that are delineated in that big yellow mark, when I was a kid growing up, because this is where I live, basically. That wetland was contiguous with the wetlands that are in here. And now they're not. Now they're separated. There's no delineation here, and there's delineation, and unfortunately, this map doesn't show the delineation because it didn't have to for this meeting. But when I was growing up, the wetland behind used to be Wixon's, behind Wixon's house, Gerard's house now. That wetland went right straight over and right into this piece. The house is right here, and that wetland, like all this delineated, there's a big piece right here that's delineated, right behind their house, standing water, and that used to be contiguous. And so through the years, that has disappeared. And the rest of it's going to disappear too, regardless of how long it takes and how minor things are. It's going to happen. So hopefully, just do your due diligence, and if you think it should be approved, you should approve it.
Thank you.
Sorry, any questions?
We're good, thanks.
Thank you.
Any other abutters would like to speak? Anyone like to speak in favor of the proposed subdivision as presented? Would anyone like to speak in opposition to the subdivision as presented? Seeing no further comments, I'm going to close the public hearing at 7:33. Back to the board. I guess I have 3 suggestions. One is that we get to the bottom of this existing or not existing easement and whatever deed it might be in. That we get a written report from the wetland scientist that did the delineation with reference to proposed road. And to follow up on Chris's suggestion of a site visit, I think it's probably pretty prudent to do that.
Could I also suggest that perhaps maybe it will come out of the wetland scientists, I'm calling it a narrative. We don't want to subject them to a 125-page report.
Right.
But we want a synopsis, fairly thorough, but nonetheless a synopsis. I would suggest that these additional wetlands, at least to the east, could be indicated there, because there's a small indication on the survey map that, graphically looks like, ad infinitum, and it's a flood zone. So Just if we could see that representation, because it's good, I think it's good to have that in the visual analysis. It just helps you remember. Yeah, it says flood zone, that's a wetland, but can we see it? So I had those three down as items for your consideration moving forward, and I think it's really imperative we get some feedback from the wetland scientists. And I mean, some of you have personal and academic knowledge of wetlands, but I mean, for a deliberation, that seems to be a very, very salient point. So I think we need a little more academic interpretation of these wetlands and their standings.
Yes, no, maybe?
Yes.
Yes?
Yep. Yeah, I think we need to at least wait for the delineation. I also would second the motion to take a field trip, take a look at it.
Okay, so we basically have, Rebecca, do you want to say something?
Not yet, but maybe in a second.
Okay. So right now, we've got kind of 4 items. Getting to the bottom of the possible right-of-way and what deed it might be on, a site visit, adding the known wetlands to the
Or just an indication of it, just so you can.
Subdivision.
Yeah.
proposal, and to get a narrative or a synopsis from the wetland scientists. Those are the 4 things that we're looking at right now.
And we also need either verbal or written permission from all the involved landowners for a site walk. So that's just kind of pro forma. We can't just go clomping out there if they're not
Yeah.
amenable to it. So. And perhaps that's something that we could elicit tonight, or solicit.
Okay.
So I guess I think we need to consider what we're gonna do with this information and whether or not the applicants are actually amenable to any changes in the existing, the plan that's been presented in front of us. Because if they're not, what's at stake here is potentially losing this entire parcel to something else. So if we are thinking, I mean, this is a minor subdivision, and it does conform to our subdivision regulations. So what's the purpose of these additional steps? Are they actually going to, are we gonna be able to convince the applicants to do something other than what they put before us? So that's my question.
The answer is probably no,
So,
from what I'm hearing.
and that's seems like that to me as well. So if there's no moving this at all, what's at stake? Losing everything, this entire parcel?
Well, it goes back to the probate court, and they come to a new settlement that the board would approve, or they can get fed up and sell it at auction, or
Right.
Well, you could continue to one more, and I know where Rebecca's going with this, but one more meeting after, one more deliberative session, continuation of this public hearing, after you get this information, maybe to just give you a little more criteria to weigh, because there's a lot in flux here. There's a lot of criteria from the different parties and the abutters, so I just think, if it
So
were me,
here's-
I'd want more information.
So here's a question. What about conditional approvals that specify where the road goes and what it has to be? Is that possible?
Oh, you would be, yes, that's definitely possible.
So we could say it
Right,
shall be.
and then if it doesn't fly, the default would be, which is not our charge, technically, would be for, if the parties are
Okay,
not
so
in
we could-
agreement,
We
they'd
could
have,
put conditions of approval that would mandate where the road went and what its construction was and so on.
but you do have 2 more items, I mean, not 2, but depending on where, I mean, this is, building this from the ground up. You also have that issue of where your projected boundary would be vis-à-vis the road, which its location or proposed location would be vis-à-vis all that information you're getting. So this is a little bit of a process here, I think, to come to a very well-informed decision. So you got a lot of variables here. So I just try to knock them off with those 4 items. That's just my guidance on it.
You guys hold your fire there for a second. Any comments from the board before we take some more comments from the presenters? Mr. Hahn? Okay, you guys want to pitch in?
Just a question on the 4 items you're discussing, the wetlands to the east of the driveway, item number 2. Would you be looking for a full wetlands delineation or just a general?
Indication.
A general
Just
indication.
That's my opinion.
Yes, that's my opinion.
And just for your information, if it helps at all, but the entire property is under current use.
And I don't mean to be speaking out of turn on this, and this isn't necessarily reflecting on behalf of my client, but just due to the discussion that's happening here. My understanding of the partition and statutes is that in the first instance, the judge would divide the property amongst the parties. And then if he finds that he can't do that in an equitable way, that is the time that he would have to be sold. So I don't want this board thinking that if this isn't approved, all of a sudden they have to do that. It just seemed the discussion was going on.
Thank you for that point. Okay, so board, I think what Rebecca says might very well be valid, but I don't think that should prevent us from going ahead and kind of making sure we have all the information, including a site visit. We have a consensus on that?
Could I just ask a question for edification from any of the attorneys? Is there a time frame on this? I know it's supposed to be expedited, but is there a drop dead date?
On your process?
Yes.
I think we're approaching the deadline. Phil and I were talking about that a moment ago with Fred and I. And I believe you should be extending, we should ask to be extending the period of time you have to decide the issue.
Yeah, right.
I think
Because
it might actually be tomorrow. I think you're right. It's very, very close. So the parties can agree to ask the board to extend the time to make the decision.
okay, you mean our the planning board governing statutes? I'm
Right.
more talking about the probate court. Has it
Oh, no, no.
put a drop dead date?
No,
Okay.
don't
All
drop
right.
that date.
Okay.
Your process, though, the
Right,
time period,
right,
and you
right.
should
We are
be
approaching-
extending that.
Yes, because we're coming at 60 days. You know, this started February 16th.
We passed over a month, so I think we're actually into way beyond 60.
Okay, so I would entertain a motion. Maybe I'll make the motion that we can continue this to a date certain pending following 4 items. Determining what right-of-ways or easements, if any, exist in the current deeds. A site visit to look at wetlands and access particularly. A wetlands narrative or synopsis from the wetlands scientists that delineated the wetlands originally. And that the wetlands be indicated on the proposed subdivision.
The adjacent wetlands, yeah, because we know there's a huge one up there.
Do I have a second for that?
Second. I second that.
All those in favor, please say aye.
Aye.
Opposed, say nay.
Can we just cite the date, please, to a time and date certain? Because this
All
is
right, so it'll
public
be
notification.
1 month from now. What's the appropriate date?
I can't see that
May
far.
18th is our meeting date, and I will just say that I am unavailable on that date.
Okay.
So if that makes a difference, that as far as the number of us there.
That might be a problem.
No, we all right. So May 18th.
Okay.
And then, Sharon, will you take care of the property notification, permission for a site visit?
Yes, and then if the parties' representatives can get some documentation to me about continuing this past the point, just so we have all the paperwork in order.
I think we can do
Yes.
it orally on the record.
Okay.
It's always done that way typically. On the record, we would agree to extend the time period within which the board has to make a decision to accommodate the requests.
Bill?
So you will not be available on the 18th.
Likely not available on the 18th.
Okay. We've already lost two people that, originally heard the first.
Who's the other person?
We had John, wasn't John the first one?
Yeah. Was Steve here at the previous meeting?
No, but we had Brian.
Brian, okay.
In terms of a site visit, is there a document you'd like to have executed? Because typically, the parties would just agree to allow the board.
Just an email to me, just something so it's written down would
I can't
suffice.
for my clients, maybe Bill will do it for his, indicating that the owners have no objection to a site visit. Certainly, I'll represent that now before the board on the record. An email confirming that's fine with me.
That's fine with us. then.
We probably want the owners with us to show us, so we're not just stumbling around.
It would be better.
Yeah.
Correct.
That's fine. That makes more sense, really.
And perhaps, Tom, I think you need lead the,
Okay, so that happened. So we're continued for another month. And we'll move on to, thanks guys, thanks everybody for slogging it out some more. Hopefully we'll get to the bottom of this next month and move forward. Okay, last item on the agenda, Mr. French, are you still here? Kevin?
oh, Kevin's in the back,
Back.
yeah.
And if I can find my cheat sheet.
It's big.
Good evening, tell me when you're ready.
Just give us a minute, Alex. Just a minute, please.
You guys
Mine
have-
won't be 9 years long.
If you guys had been here 30 seconds earlier, you could have gone for.
Really? You were?
Actually, you were you were in the,
On the
yep.
hall?
Well, Alex
gold
was,
room
but
there.
Kevin wasn't here, so.
Oh,
No, we, hi. I thought we'd done good. I thought we were on time, but you're right, we were.
Well, this is for another project. Right.
Another.
'Cause you're involved with Kathy's
Oh,
project
yeah,
also.
but
so,
this
yeah.
is not the prior.
No,
this has nothing to do
that's
with,
out the door.
Boulder Point. Okay, so my name's Alex Ray. I live in Holderness, and I'm here representing a piece of land I own, commonly known as the Italian Farmhouse. And this is what I'd like to think is an informational meeting.
It's just, yeah, it's
Informal,
non-binding.
heads
yeah.
up information about it, just so that when we do come back, you're up to speed. Here it is. I bought the Italian Farmhouse in '89. It was an ongoing restaurant, and we've operated for whatever that is, 27 years. I was amazed to figure out tonight, 28 years. Holy mackerel. And along the way, we've modified the building somewhat, and the primary building has 150 seats on the 50 dining seats and an apartment upstairs. A ways back that I can't really guess the year, but I'm going to make up a year, about in the late 90s, we removed a greenhouse from the Drew's Florist place over in Bridgewater, River Road over in Bridgewater, because Forrest died and Mrs. Drew didn't want to do it anymore. And she said, "You want the greenhouse?" I said, "Yes." So we took it apart, cleaned up her yard, moved it to the Italian Farmhouse as a summer-only place for functions. And it's been there since, for the last 20 years, roughly. It has its drawbacks, a greenhouse, and there are 4 things I can think of: hot, cold, rain, and bugs. So that covers that. So it was built and holds 125 people. So the sum total of the existing building is 275, 150, and 125. I'd like to discontinue the use of the barn, of the greenhouse. And have an affinity for barns, and I found an old barn falling down in Canterbury, and it's about my fourth barn, by the way. And the lady couldn't sell her property and pawed on me for 5 years to take the barn down, and I said no, and finally took it down this fall. Disassembled it, brought it up here to replace the greenhouse. The greenhouse maybe just, it'll stay for this summer, but no way we'll have a barn by this summer. My plan is to not use it any longer for dining for the 125. It may stay for, guess what, a greenhouse, and use it as a propagator, whatever the heck that is, to grow plants and vegetables for us. The new barn that we have designed, that you'll see for a second, is at least our first draft is 250 seats, which would be an additional 125 if you're with me on that. So our calcs for what we want to do will be based on the expansion of that property's seating from 275 to 400, or 125 more seats. That's our plan. Some of the things you'd like to know, well, we have to put in a sprinkler system, we have to grade our parking, we have to upgrade our septic system, the usual things. I'm here to ask, is that expansion of those 125 seats necessitate a site plan review, or is it just an expansion of the restaurant? And if so, why? It's not a change of use in my book. It's like putting a wing on the building, except it's disattached. So I'm asking you to consider not even necessitating a site plan review, and if so, what are the criteria for that? That's the first question, and I'm going to let Kevin, or ask Kevin, to answer any questions about what we're doing while we ponder. Is that okay, Kevin? Just familiarize yourself with what we're doing. There's a river and a railroad track, and by the way, this land is roughly 40 acres.
Is the barn sitting there in pieces right now? Is that what is, yeah?
Yes, it's disassembled, it's the frame, and waiting for new life.
Yeah, the barn is actually sitting right in this field. Right
Yeah.
here now.
What I didn't say is I
every day.
bought the McDonald property about a year ago. I forgot to mention that.
Yeah, so now this is the property line that exists between the Italian farmhouse and the McDonald property, but Alex owns them both now.
So are you going to have a merger or no?
No. I also wanted to say the barn was going to be on that property, and that was one of the reasons I bought it. It now is as you'll see in a second, is on the existing Italian farmhouse property. So there's no changes of boundaries or ownership. It's relatively irrelevant that we bought the McDonald piece. To tell you the truth, the reason we purchased it is we owned down to the river, but had to go through an unofficial easement through the McDonald property to get to the river. So I bought the McDonald property to access our river property. There. You're on.
Just which you have there, this is the existing farmhouse building, the existing greenhouse, which I originally had to be removed, but he may keep it as just a greenhouse, but not for functions. So the idea is to reassemble the barn in this area and replace the use that is presently using for the greenhouse. This is the existing parking that exists now for the greenhouse and the restaurant. And what we would propose to do is we would need to add a little more parking because we came up with 125 more seats. And that would basically, we would kind of create a green buffer area here that I've shown. And that additional parking would be in this area down here. The basic reason being because Alex wanted to do something that separated the function parking from the restaurant parking, so that because there may be times when they're both operating, when both going on, and didn't want the function activity to utilize all the parking and then everybody drive by and say, oh, I can't stop, the restaurant's full because the parking lot's full, and then have the function activity take away from the restaurant. So basically, we're just going to do a separation for those extra parking spaces.
Still on the Italian farmhouse property, which is about 30 cars, because there's a ratio of 4 people per car, right?
Right, it's, well, 120, there's 4 people per seat, 125
Per seat,
seats.
I mean, yeah.
It comes out to be 32 extra spaces.
So Kevin, did you say the new parking is going to be on the other property or
No,
not?
it's all on the
You
Italian.
guys keep it up here.
It's all on the existing Italian farmhouse
So that's where the
property.
access to the proposed barn
Essentially, yeah.
is going to be from.
This is the,
Proposed parking.
this access road is the one that was talking about.
This is the green area that was going to put.
So there's a
current
pre-existing access from Route 3 on that second parcel, which will be utilized
Oh, yeah, it
for the
is.
barn.
No,
Okay.
no.
McDonald property will have nothing to do with this whole project, not
Except the
access.
barn will be on it.
No.
No, the barn is presently sitting on it in its disassembled state. It'll be reassembled on.
Okay, let's see, because I'm seeing, this is the first time I've seen that, so,
Yeah, right,
yeah, okay.
Just forget McDonald's existed, I just,
Yeah.
it's another issue, but and we will, we're not gonna use it for the barn, that's all.
Can I look at that? I haven't seen
What do
it.
you want to look, why do you want
Except
to
for
get this?
parking.
No,
Just
Well,
make
it's
something
got,
up.
on, at least that's kind of delayed. Parking area on McDonald's property. Down below the green area there.
Yeah,
is
this
the-
is the edge of the parking now.
Oh.
This is the present.
Rectangle, it's a
property.
oh, yeah,
cemetery.
you're right, I'm
Yeah,
sorry.
yes.
I'm thinking of using the easement road as a boundary, so.
Right.
Oh, okay.
So you are right.
Okay, I'm sorry, I thought the cemetery was the barn.
Well, that's a cemetery.
Well, I can't see that first.
And Alex owns both pieces. If you wanted to do it and keep them separate, we might adjust that boundary.
Could do a BLA.
I just retract everything I said?
Yeah, yeah.
Okay.
And me too, because I said it wasn't on the McDonald property.
Rebecca, do you have a question?
No, that was answer my question. There will be a boundary line adjustment if you're putting parking above the.
I think that would probably be, originally the barn was gonna be over here, you know, and we just for
Yeah.
design reasons, it's gonna be here. And I was thinking of this as being the boundary, so we could do a BLA and put the
Yeah.
boundary over
So
here. Because I do
you're
want.
looking at a site, you're looking at an expansion of use, so you are looking at a site plan, but it's minor.
Okay.
Because you've already got it drawn out. So you know that drill, you just jump through the hoops and explain to us formally what you're doing and.
Yep, that's pretty much it. We did want to ask about height.
Right. If I could change this for a minute. And like Alex said, he bought an existing barn that he's rebuilding, and the height of that barn is, what's this document? The height of the barn is 47 feet, or will be 47 feet from the average ground level. It is going to actually have a basement in it as well, which will be accessed on the lower side, but it's a walkout thing. That'll be below grade. And the most of the upper area is just the superstructure of the barn, really. And it's unoccupied space. So there is a provision in the ordinance when it's up to, because it exceeds obviously the 35-foot maximum. In the ordinance, it does mention something about if it's unoccupied space or things like that, you don't need a variance. I prepared everything for the variance just in case. So, and the reason, you know, I could go through all the reasons for it, but you know, you can't put the building back together in a, you know, smaller.
Configuration.
Can't make it any shorter.
smaller, yeah.
Probably could, but we want to make the original barn the original barn.
Bill?
Is the cupola, is that the one that puts it over the?
No, it's the ridge line.
Okay.
And I thought it was 42, I'm sorry, but
Alex, is this functionally different than what you're doing now with the Italian farmhouse?
it's doubling the capacity of the function space from 125
You have
to
a function
250.
space now.
Yeah, but it's summer only, but that doesn't count in the business world. The greenhouse holds 125, and we do from, Memorial Day till almost Columbus Day or something, we do functions out there for 125 or less. This will be 250, which is an addition of 1.25.
This is going to be summer too?
No, this will be year-round. That's the other thing, is we can't do anything out there in the colder season, but we can with this. This will be year-round.
Yeah, that's where your 2 levels of expansion come for criteria.
Looks fun.
That's it. I think that's, just so you know,
I
we'll
think
be
it's a
back with more details.
Great addition. You know, I mean, Kevin knows the drill about parking. Still accessing the same driveway point onto
No curb cut changes are
Route 3
anticipated.
because it's a state driveway permit. Yeah, site plan, you may have to check with them on just technically an amendment, because
Check
in the
with who?
DOT, the district.
Okay.
I can help, I'll help you with all that as we go along. It's just, it's just crossing Ts and dotting Is with the paperwork, pretty much.
Yeah, and there wouldn't be, I mean, we would be using the same.
Access point, yeah.
Yeah, we haven't changed the curbs, the driveways at all.
I don't know if they want to see any changes to the interior, and it probably won't require any changes to the access point, but they want to know what's going on, is all, so, yeah.
You think you might be cleaning up the access to Intervale Cemetery, just to
What's that?
clean up the access to Intervale Cemetery, just to,
Yeah, I suspect that the access to the cemetery was that same old road.
yeah.
I think it, I think it is.
Was the same, you mean the easement?
The same, I suspect it was the same,
Right away.
in this old existing right-of-way.
It's a very undesirable entrance.
Yeah,
That's why we don't want to use it,
No
because
curb.
Right.
2 reasons. It's on a curve, and it has a climb going out, and
Yeah.
those never
Yeah.
work. So
It hasn't been used.
I'd like to eliminate it.
Visited it just to visit all the cemeteries and.
Yeah.
Yeah,
No, it's a Michael Tulip's access to his land down below. Now it's our access for who knows what, but we can get to our land down there. Nice beach. That's it.
Wood turtles.
Any questions about it? It won't be ready till a year from now, the spring of 18, if everything goes well.
So just for my edification, because I still have vacation brain and I was opening your package tomorrow, there's a possibility with your use of the space that will be there in the barn to get around the variance, because it'll be non-utilized. It'll, like atrium space, just air.
In your subdivision regulations, it mentions if it's not
Site,
in
site
site plan review,
yeah,
in zoning ordinance, actually. It mentions if it's non-occupied space.
cupolas, atriums,
Right,
whatever,
right.
yeah.
So I submitted the application,
Just to get in,
basically just because of the times were different. Their deadline was, before yours, so I couldn't
okay.
get here to ask you before
No, that's fine.
deadline. So I submitted it in case we had to go.
You mentioned that in the application. Like I said, I was going
Yeah,
to
yeah.
start that tomorrow for
That's
ZBA.
okay.
This is ZBA.
That's fine.
Yeah, okay.
That's,
all right.
I did, if you don't need it and you want to save me the $220, by all means, that's okay with me. So,
I think we were hoping to ask for the ZBA direction from you people. Do we have to wait and do the ZBA after we come to you, or can we go there? Because that would kick back another month for the
No,
variance.
you go to the ZBA first on this, because it's a variance and it's physical.
Yeah.
Yeah, but let me duke it out in my own brain and I'll get
I mean,
back to you on that.
if we go, you have the stuff to.
Yeah, no,
send out,
you're
so
fine. Yeah,
it's,
you're good.
you know.
Yeah. If I determine it's needed,
Right.
you're in the
You already
hopper.
got the stuff,
Yeah.
yeah. Right. And I didn't want, the other thing is, I didn't want that going out before you guys knew what it was for. Because, say, well, what's somebody asking for a variance for? We haven't even seen what it is. So that was kind of the purpose. It's kind of a timing thing. So.
It always is.
Do I have a cut in there, Kevin, of that? I mean, I think it's about 16 feet at Cathedral, and that barn's 10, 12, and 40 feet across, so it's really like 16 feet of just
Yeah.
cathedral
Is
wood
there,
ceiling and beams.
there any photographs from before it was demolished?
Sure. Not here
The
now.
interior, the interior.
The interior during its demolition, we have some very good shots
Yeah.
of it.
Just to help me get a spatial.
It's just a barn, good-looking barn. It was 4 stories tall, it's gonna be 3 stories tall.
If you go on our website, which is cci.com, and go to the video section, there is a video of us dismantling that barn.
Okay.
by Alex.
Good thinking.
Okay.
There's all sorts of.
Might be on our website, too.
Picture chronicle. It's one of the oldest barns in the state.
What's the date of the video? Was it this year?
Yeah,
It's
it was
recent?
it was this, but just click on, just click on.
Oh,
the
all right, thank
website
you. Thanks,
And
Jeff,
go to the
okay.
video
Yep.
section.
Cool.
And there's a 2-minute or 3-minute video.
Oh, you know what else? You can go to Boston Chronicle Archives.
Boston Chronicle.
They ran a good story on it.
It was actually, you're right, it was a 3-story barn.
Yeah.
We're cutting it off and using 2 stories of it.
So anyway, that's the story. It's called the Peverly Barn. It's really was an interesting barn. It was just, sorry, but it's funny, it was a potato farm. And they have, in the main floor, they have a scale as big as this table, if it were square, where the wagons would come in with the potatoes and weigh them in the barn. The whole, the wagon would go on the scale and, for 4,500 pounds. It's pretty cool.
Do you have that scale too?
Yeah.
Are you going to weigh a party and
You know
charge
who
them
you're
by
talking
the
to.
Well, I think that's going to happen because you get the wedding party on the scale and you say the guy who gets closest gets a $1 gift certificate.
It took almost 6 or 7 weeks to take it down and number it and truck it
I'll
up here.
bet, yeah.
And there were cranes involved and lifts, and it's amazing that it was built, a couple hundred years ago, and all they had was a gym pole and oxen to set that whole thing.
Yeah. And
Because
it's
it took a
stood.
long time, and it's gonna take a long time even with modern equipment to put it all back up. So,
That's wonderful.
it's pretty
So
cool.
it's being engineered now, because today, you know what it's like.
So you're looking to come before these guys for May 18th?
Yes.
So I'm not sure.
Submittal
I think the
is
deadline's next Tuesday then.
the 20th.
Site plan.
I realize that, yeah.
Just keeping you on your toes, Kevin.
Kevin's not doing anything this weekend.
No.
After he does it.
Do you want to keep this?
Yes, well, is this what you've given me for?
No, I'm going to put a little more on what I submit. Yeah.
This is in the ZBA package essentially?
Yeah.
Okay.
Yeah,
No,
yeah.
you can have it back if you want, whatever.
Thank you for your ear.
Thank you, gentlemen.
Thank you.
We'll be back. What's the date of the planning board?
18th.
Good, yeah, that's right.
It'll be another fun meeting.
Sure.
Get here early.
Yeah, get here on time and
Get
you.
it early.
Get a good seat, get here
I
early.
should have said we left the door open, but that's okay. I learned something from that meeting.
Thank you.
Any new business tonight from the board, Sharon?
No, except everybody needs to be soliciting a couple planning board members.
I don't know what happened to Mr. Dutel, but he owes us one.
Yeah.
Yeah.
It's got
Because you
some-
can't leave till you get a replacement,
I
unless
gotta
you
come
become
up
a
with one, too?
selectman. Unless you become a selectman, it's a closed loop, so.
Okay, any comments from the public before we wrap it up?
Nope, the public is in session, so.
Yeah.
Public is in session. All right, do I have a motion to adjourn?
So moved.
We are adjourned. Thank you, one and all.
Thank you.